Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
This is the next search on February 28, 2020, 7:44 p.m. How, does the FBI find people, and people is misspelled P-E-O-O-P-L-E. Did the defendant find out how the FBI finds people in this case? Oh, she found out.
What more do you need to see?
Sorry, I didn't know you could see me. You could see me dancing. You could see me jamming. Welcome back to the Court of Public Opinion. I am the Recovery Addict. Thank you very much for joining me. Big shout out to Megan Fox, who broke this news today. Got to give her a big shout out on that. She was doing a live stream with this read through and analysis. We're going to do the same sort of thing here, more of a just a straight read through for those that want it all in one piece. Appreciate all the work she does over there. Great work, Megan. Thank you very much. I did not read all of it, but I've seen parts. I have to save some of it so I can genuinely react to the way I hear it the first time. But we have the response from the judge. We have the response from the judge. We realized that just the other day, I think it was filed on the 29th. Well, the defense asked for. They told the judge it was the whole camel's nose thing, right? We had the defense saying, "Look, judge, we've got the camel's nose in the tent. We've got you to agree to say, yes, we're going to have a juror interview. But now it's not enough. It's not enough. We need more. We need the entire camel in the tent. We'd actually like a herd of camels, and we'd like to bring them through and make a little circus right here in your courtroom." And the judge said no. And as a matter of fact, the nose is all he's going to allow, and that's it. And he's holding firm. We have the document now. It just came to us just briefly. Just moments ago. Hang on, let me get to the right page. Make sure I've got everything in order. And it starts out, the first two words are all you need to know, but we're going to read all the words. But it is so good. It's so good. The first two words as you read them, it says order denying defendant's motion for reconsideration of the scope of the juror interview. They wanted it to be so much bigger, right? They wanted it to be huge. We're going to read through this, and you have to realize this is Judge Carroll speaking. This is not Attorney Anderson. This is not Mr. Shapiro, Mr. Hunter. This is not Mr. Hughes. This is not Nick Whitney. This is not Ms. Carrell's. This is the judge speaking here. This is the judge issuing an order. And this is laying down the law, quite literally, as to what is going to happen. So we're going to read this here together. I'm going to read it for you. Hopefully, somewhere along the line, my kids will bring me some more water so we can all not suffer. As you know, it's difficult. It's difficult. All right, let me page them and order water right now, or else it won't arrive. I can promise you that. Hopefully they heard that. I asked nicely. I did. All right, so this is Judge Carroll. Order denying defendant's motion for reconsideration of the scope of the juror interview. Before the court, without hearing, is defendant Johns Hopkins All Children's Hospital's motion for reconsideration of scope of juror interview. That means that the court, the judge, has to decide this. Get tissues for laughing tears. Okay, I have tissues. I have tissues for laughing. They're right here. Where the box is it's almost transparent. It's a special box. It sort of disappears. Yeah. But they're on hand. So he's saying without hearing, meaning he said, you filed it, I'm responding. There's going to be no back and forth, us talking about this, arguing this in court. It's just going to go ahead. And he says, without hearing, we're denying this. By order dated December 20th, the court granted a limited interview of juror number 1, which is set to occur tomorrow, January 3rd. That order discussed the original and 3 supplements. The court explained that it would conduct a limited juror interview on 4 topics. The court also concluded J. Hatch's 2nd and 3rd supplements were untimely. In J. Hatch's current motion, J. Hatch takes issue with the scope of the juror interview permitted by the court. The premise... Oh, I need to fix that so it doesn't do that. It's really nice and handy, but no, I need continuous scroll. Okay. let's see. The premise of J. Hatch's motion is the unsubstantiated allegation, that juror number 1 will lie to the court, and therefore the court's juror interview to be conducted tomorrow is inadequate. J. Hatch also contends that its second and third supplements should be deemed timely, or at least find good cause for the delay. Finally, J. Hatch suggests additional improper communications between juror number 1's wife, plaintiff's counsel, and the jurors that require additional inquiry. J. Hatch, in its motion, concedes that its 3 supplemental filings were prompted by the sleuthing conducted by the internet community. Read Reddit. Okay? The court will address J. Hatch's contentions based on the order presented. J. Hatch presented them in its argument section beginning on page 12 of the current motion. J. Hatch first argues that its original juror interview motion was timely, and therefore its supplements that added new claims that were not timely should relate back to the initial motion. The court disagrees. First, J. Hatch has not supplied any case law for its retaliation back proposition. Second, J. Hatch's reliance on the internet communities to conduct its own research does not transform an otherwise untimely supplement in a timely supplement based on good cause. Third, even if the juror interview rule permitted relation back, the subject matter of the untimely supplements were not remotely or substantively disclosed in the timely filings to permit there to be relation back. They said you can't connect these two. Fourth, J. Hatch's claims in these filings are not material to the trial in this case. They don't even matter. Okay, your complaints are invalid. Good day, sir. As it relates to the wildly speculative claim in the second supplement that juror number 1 was calling Dr. Sally Smith a Nazi, as evidenced by juror number 1's handwriting on a few capital letter S's on a juror question, and by extension implicating J. Hatch, nothing in the original motion or first supplement come close to addressing that topic. J. Hatch's trial team included at least 5 attorneys and 2 paralegals, each of whom attended most days of the trial in addition to whatever legal professionals J. Hatch had working behind the scenes. One of the primary attorneys on J. Hatch's team, who made substantial argument before and during trial, is a former chief judge of the 2nd District Court of Appeal. Under J. Hatch's theory, it necessarily follows that none of these highly experienced and knowledgeable legal professionals comprehended the meaning of the juror note that they visualized and was in their weeks before the trial ended. So you've got really smart people here that were looking at this, and none of them said there was a problem. Why don't you bring water to the table? Virginia, this sounds like it requires forethought. Chat on the screen. Sorry about that. Stop. Before we go too far, Ash Nicole, you were first in chat. I apologize. Congratulations. You've won the internet tonight. I see you're up to the task because you yourself, you have an S with the sharp corners in it. So you're good with electricity. I think that's what it symbolizes. It has nothing to do with some historic oppressive party, anything. So you're good. You're good. Congratulations, Ash. Thank you very much for being first in chat. The court, I need to go to, speaking of which, there we go. Let me pin this. There we go. Good. All right. The court does not suggest attorneys have a monopoly on knowledge or reasoning skills. Far from it. The court, though, makes it a simple point in the circumstances in this case that J. Hatch did not show good cause to explain why its invocation of the alleged Nazi symbolism was untimely. This is especially true where Florida has a strong public policy against allowing litigants either to harass jurors or to upset a verdict by attempting to ascertain some improper motive underlying it. Whoa. And even if this issue were timely, or there were good cause to excuse being untimely, there is no sworn evidence before the court suggesting that juror number 1 was invoking Nazi symbolism. Nothing about J. Hatch's pointing on the Simon Wiesenthal Center website results in the conclusion or even plausible suggestion that juror number 1 did what J. Hatch theorizes. Saying it confidently in court filing does not make it so, and suggesting the court's separate ruling on the juror disqualification motion would have been different had the court appreciated the obvious Nazi symbolism J. Hatch now believes exists by a couple capital S's is unsupported. The court continues to find no objective evidence entitling J. Hatch to a juror interview on the Nazi symbolism issue, even if this issue were timely, which it is not. As it relates to the alleged non-disclosure of juror number 1 or a family member being a victim of a crime, question 18A, as asserted in the third supplement, this too is untimely, and there has been no good cause to show excuse the lateness. Camilla, welcome to the gallery. Thank you very much for being a new member. You can never leave now. Just wanted to let you know. Thank you. In addition to Jay Hatch's substantial trial team, defense counsel quickly solicited an untold number of unknown others to assist with Jay Hatch's investigation of juror number 1. In a November 11th, 2023 internet post, this is the judge saying that Jay Hatch, in addition to Jay Hatch's substantial trial team, defense counsel quickly solicited an untold number of unknown others to assist with Jay Hatch's investigation of juror number 1. He's saying this is what you did. Okay? In a November 11th, 2023 internet post attributed to Jay Hatch's attorney, Ethan Shapiro, he names him, which was a day and a half after the verdicts were released, Mr. Shapiro encouraged a pro-Jay Hatch internet community to investigate juror number 1, which is something I believe the attorneys are not allowed to do. Am I right on this? Can somebody correct this? Am I right on this? And would that make the sworn statement? No, I'm not sure. I don't think he made a sworn statement to that effect that he filed today. That was that he didn't reach out to the juries. I think he said something about deputizing. We'll see. We'll see. Anyway, okay, so that's interesting. He said, and here's the quote. The judge includes it for us for our reading pleasure. Hey, I want to thank you and everyone else who is sleuthing this so carefully and meticulously. I've gone through the Reddit thread on juror number 1 with almost 1,000 comments. Everyone on the defense team is monitoring this closely. If anyone in the community has comments to make, you can feel free to keep posting them because we're going to read all of it and put it towards emotion. I agree the idea the wife knew when a verdict was coming and what they were arguing about it shocking, and I hope the judge will feel the same way. Whoa. So this is what the judge says. You have deputized the internet. That's what he's talking about. Is that something that the attorneys are allowed to do in sleuthing juror number 1? Considering that previous statement that says that in this Baptist Hospital of Miami versus Mailer, it says Florida has a strong public policy against allowing litigants either to harass jurors or to upset a verdict by attempting to ascertain some improper motive underlying it. Is that not what is being spoken of right here? Through an unintended mistake, it appears juror number 1's name was publicly visible for a short time on the court's docket on the afternoon of November 9th when the phase number 1 verdict form was first published. It was. Despite this army of internet detectives, Jay Hatch relies on the theory that the alleged criminal assailant shared the same last name of juror number 1's new wife, which was different than juror number 1's last name. Think this through. Jay Hatch says the alleged criminal assailant shared the same last name as juror number 1's new wife, which was different than juror number 1's last name. That simply does not demonstrate good cause, regardless of the legion of individuals working on Jay Hatch's behalf to investigate juror number 1. Even if this issue were timely, or that good cause had been shown, Jay Hatch has not shown the alleged non-disclosure was material to the jury service in the case. Materiality must be analyzed case by case. A juror's non-disclosure of information during the voir dire is considered material if it is so substantial that if the facts were known, the defense likely would preemptorily exclude the juror from the jury. Question 18 on the clerk's form jury questionnaire, which is the form used in both criminal and civil cases. This question was not on the special questionnaire used for this trial. Question 18A asked if the potential juror or a family member had been the victim of a crime, which tends to be more relevant in criminal cases. The current case, of course, is not a criminal case. Jay Hatch's own actions during the individual questioning of potential jurors demonstrates the content of question 18A was not material. Critically, Jay Hatch never discussed with the potential jurors the subject of question 18A. Oh my goodness. Yes, the judge calls out Shapiro's Reddit post. Wow. Mrs. RA is going to come in and tell you to slow down. Thank you, Karen. Thank you. I appreciate that. And Marilyn, congratulations on 10 months. Glad the holidays are over. Can get back to my peeps. Love owning a bakery, but in the holidays, LOL. Marilyn, send samples. That's all I'm going to say. And Kamala Norris, welcome to the gallery once again. So good to have you here as a member. Thank you so much. I'm going to slow down a little bit. How about that? I just get so excited. All right. So he put that in bold. I have not changed anything. This is the judge. The judge bolded this. I did not. The court conducted 3 days of individual voir dire, followed by 1 day of group voir dire. the court has the transcripts of days 1 and 2 of the individual questioning, which are being filed concurrent to the release of this order. Ultimately, no one from day 3 of the individual questioning was a juror or alternate, so the court is unaware whether any party has paid to have the individual voir dire from that day transcribed. It doesn't matter because they didn't choose anybody from that day. The court has reviewed the day 1 and day 2 transcripts. Despite having the opportunity to ask questions, J. Hatch never asked a single question of any prospective juror concerning a yes response to question 18A. Although the court does not have the day 3 transcript, the court does not recall J. Hatch asking any questions of a prospective juror concerning a yes response to question 18A. In fact, the word victim was uttered a grand total of 1 time during the entirety of day 1 and day 2 by Mr. Anderson in a different context. See day 1 transcript, page 215, line 13. The court notes, on day 1, a total, oh man, Hollister, we will save it for you. We will save it for you. It'll be on the rewatch crew. It's going to be great. On day 1, a total of 12 prospective jurors answered question 18A as yes. And by the way, congratulations on the 1 month of membership. Of these 12 prospective jurors, 5 prospective jurors advanced to the group questioning stage. On day 2, a total of 14 prospective jurors answered question 18A as a yes. Of these 14 prospective jurors, 4 prospective jurors advanced to the group questioning stage. Of further note, 1 prospective juror, juror number 97, was seated on the jury, and 1 prospective juror, number 137, was seated as an alternate juror. Defendant J. Hatch had remaining preemptory challenges at the time the jury was seated. So we had people who said yes on 18A, and they made it on the jury, and J. Hatch did not exclude them. They're basically, the judge is saying this is a non-issue because it wasn't an issue for you then. You can't come back here now and say, oh, because he answered differently on that one, had he answered correctly, we would have excluded him. Because they wouldn't. They didn't in this case. On day 3, a total of 13 prospective jurors answered the question 18A as a yes. Of these 13 jurors, 6 prospective jurors advanced to the group questioning stage. The first table below depicts the potential jurors answering question 18A as a yes that advanced to the group questioning stage, the day that juror went through individual questioning and the transcript page that questioning began. The second table depicts potential jurors answering question 18A as yes, but were dismissed for cause during the individual questioning stage for a reason other than the fact that their family members had been a victim of a crime. Remainder of page intentionally left blank. And here we have a chart. Let me just put this out here right now. This is Lebad charting. Okay, this is Lebad charting. Judge. It makes sense. This is the bare minimum. It has the data and where the reference is. So you've got the juror numbers, the day they did it, and the transcript page. The juror numbers, the day they were interviewed, and the transcript page, right there. So it's there. The lawyers know what to do with it, but that's not a pretty chart at all. J. Hatch's current claim that the content of question 18A was material in this case simply cannot be reconciled with J. Hatch's action, or more precisely, lack of interest in the content of question 18A during jury selection. J. Hatch has not even attempted to explain why did it not ask any prospective juror answering yes to question 18A about the situation? Why did it not seek to challenge any prospective juror for cause based on question 18A? Why did it not exercise a preemptory challenge on either juror 97, who was seated on the jury, or jury 137, who was seated as an alternate, despite having 2 preemptory challenges to the main panel and 3 remaining preemptory challenges to the alternate panel? This is nothing more than the proverbial Monday morning quarterbacking after knowing the result of the game. Did the judges' team, did they lose? Did Florida lose? Or were they even in the playoffs? I don't even know. You can't go back after and look back on it. Samantha Terry says, yes, we have been accepted into the pool media for the tomorrow's interview, or for tomorrow's hearing. That's great. Okay. Let's see. It cannot do what Shapiro did in reaching out to Reddit, said Savannah Gary. That would be deputizing them to do something they. Okay, if that's the truth, Savannah. If that's the truth, sanctions. That's it. Sanctions, and big ones. Let's see. Inverted giraffe, introverted giraffe. That's worse. Inverted is also bad. Glad I'm caught up. RA at 1.5 speed is quick. All right, I will slow it down a little bit. All right. So we've got the Monday morning quarterbacking after knowing the result of the game. The court notes one final issue with respect to question 18A. Juror number 1 marked yes to a question 18B, which is whether he or a family member had been charged with the crime. When the court asked juror number 1 during individual voir dire concerning question 18B, juror number 1 indicated that his stepson had been charged with the crime. This is the same event that J. Hatch contends juror number 1 failed to disclose on question 18A. J. Hatch had no follow-up questions. So he missed it on 18A, caught it on 18B, and they're saying because he missed it on 18A, we would have excluded him. Not there. Preemptory is not pre, it's unblockable, not before. Peremptory, not preemptory. Okay. I pronounced it wrong. Thank you, Mathis. I pronounce many things wrong, and I will continue. I reserve the right to continue to pronounce things wrong. But yes, the wording is correct. Peremptory challenges are not blockable, meaning that the other side can't say, hey, I object, and the judge rule in one of them's favor. You have the right to exclude somebody with or without cause. And once you issue that challenge, it is done. They are gone. It doesn't matter if everybody else wanted him there. It's unblockable. Thank you for that correction, Mathis. I stand corrected, and I'm a smarter man today because of you. Am I still speeding from your chocolate? My kids ate the rest of the candy bars. They did. So I was going to have one right before this. Where'd we end up? Well, the court understands that a party is entitled to rely on jurors' response during voir dire and not conduct an exhaustive public record search at that time. Under these circumstances, the court cannot find good cause to excuse J. Hatch's failure to raise the question 18A issue within 15 days post-verdict as required by the rule. Even if there were a good cause, which there is not, J. Hatch has not shown the question 18A issue to be material in this case. J. Hatch is entitled to no relief on this claim. Done. Part B, the court's scope of juror interview is appropriate. Shockingly, says the judge, J. Hatch next contends by implication that if the court directly asks juror number 1 under oath or affirmation concerning the subject matter of the permitted interview, juror number 1 will lie, and that an interview without invasive and extensive discovery will be worthless. The judge is shocked that the attorneys assume that juror number 1 will lie when asked if he followed the rules. That's their assumption, their basis for the argument. J. Hatch wrote, an interview that contains only questions about direct communications and shared information will yield no useful information and reveal nothing about whether juror number 1 engaged in misconduct. Given the strength of the evidence that juror number 1 omitted multiple pieces of material evidence from the jury form, harbored a pro-plaintiff bias during trial, and failed to disclose his wife's extensive contacts with pro-plaintiff social media accounts, including her presence in the courtroom and friendship with plaintiff's advocate, hey Jules, much more is required to determine whether J. Hatch received a fair trial. These are incredible statements. The judge is very careful with the words he's using, and he's using very, very important words. These are incredible, non-believable, have no credibility statements. There is scant, if any, evidence underlying these ambitious statements. As to the strength of the evidence, J. Hatch first points to juror number 1's omitting multiple pieces of material evidence. The court already demonstrated why question 18A issue is waived and alternately not material. As it relates to juror number 1's answer to the DCF opinion question, an answer about knowledge of attorney Deborah Salisbury, the court has already included those issues in the permissible topics. The court is aware of Mrs. Salisbury's affidavit, which appears to further erode the strength of J. Hatch's allegation on that claim. Next, J. Hatch replows the same infertile ground. Oh my goodness. Judge Carroll replows the same infertile ground. No matter how many times you plow bad soil, it does not turn into good soil. And the judge says, next, J. Hatch replows the same infertile ground that juror number 1 harbored a pro-plaintiff bias and otherwise formed a final and fixed opinion during the trial, contrary to the court's instructions. This was the subject of J. Hatch's November 2nd motion seeking to disqualify juror number 1. The court previously rejected that premise during the trial. The reality is juror number 1 is a former law enforcement officer that J. Hatch welcomed onto the jury, despite having available preemptory strikes. And doing so was consistent with the plaintiff's argument during jury selection that J. Hatch deliberately attempted to eliminate women from the jury based on their sex. The plaintiff says that this is what they did. So Mr. Anderson, as their side, says J. Hatch didn't want women on there. They didn't want women on the jury. Regardless of J. Hatch's motive in keeping juror number 1 on the jury, juror number 1's questions during trial demonstrated that he liked to confront witnesses with contradictory and disputed evidence, which in this case was legion. They do not show a bias against J. Hatch or a violation of the court's instructions not to form a final or fixed opinion until deliberations, for instance, and focused more on the time frame immediately before the disqualification motion. On November 1st, 2023, the day before J. Hatch's jury disqualification motion, juror number 1 sent a note to the court and the attorneys requesting scholarly information as to approved treatments for ketamine in 2016 and currently. Interestingly, on October 10th, juror number 1 previously questioned Dr. Kirkpatrick, the doctor who initially prescribed ketamine to Maya Kowalski, whether CRPS was not well known and difficult to diagnose, which by implication would make the standard of care more beneficial to J. Hatch. On October 24th, I think that's year 2023 because year 203 was a long time before then. Juror number 1 asked similar questions to J. Hatch's witness, Dr. Crane. Certainly, these questions indicate that juror number one, as of November 1st, neither had a fixed or final opinion in favor of plaintiffs nor was biased against J. Hatch. Additionally, juror number 1's questions to Dr. Kirkpatrick on October 10th show that he wanted to know about the board certification and whether Dr. Kirkpatrick complied with Dr. Sally Smith's request for records. These questions supported J. Hatch's theory of the case. On November 1st, 2023, the day before J. Hatch juror's disqualification motion, juror number 1 questioned Maya Kowalski, seeking clarification of whether there was a before and after court photo session on January 6th. He previously had asked Maya the same question on October 9th. J. Hatch suggested during trial there were different photo sessions while Maya Kowalski testified there was only one, and J. Hatch used this disputed evidence to try to discredit Kowalski's testimony. In 2 separate questions to Kathy Beatty on October 31st, juror number 1 assumed there were 2 separate photo sessions, which was consistent with J. Hatch's theory. On October 26th, juror number 1 asked Nurse Alside clarifying factual questions about the actions on January 6th, whether the parents had consented to the photos, and were they placed into Maya's medical chart. On October 11th, juror number 1 asked Dr. Pardo whether there were written operating procedures concerning the taking of patient photos, I think it means patient, not patent photos, and whether private phones, as opposed to J. Hatch phone camera, were allowed to take photos. Excuse me. On October 9th, in addition to asking about after photos, juror number 1 asked Maya Kowalski to clarify if the photos were in her medical records. Again, these questions, especially after questions, aligned with J. Hatch's theory of the case. Certainly, they do not show any final or fixed opinion or bias against J. Hatch. The judge has done his homework. I said this over on Megan's stream, but he understood the assignment here, and he has done his homework completely and thoroughly on this, and is showing the results. He's proved he's showing his work here. On October 30th, juror number 1 attempted to ask several questions to Nurse Thatcher about propofol and pushing that drug through an IV line. While the court did not ask all of them, J. Hatch repeatedly attempted to paint Beata Kowalski, an infusion nurse, as pushing dangerous drugs through Maya Kowalski's existing port. If anything, these propofol questions favored J. Hatch's efforts to discredit Beata Kowalski, and certainly do not show any final or fixed opinion or bias against J. Hatch. On October 25th, juror number 1 noted to Nurse Rec that it was kind of her to do Maya Kowalski's laundry. Another juror also noted the same thing. One of juror number 1's questions to Nurse Rec was whether Maya's parents were negligent in not doing her laundry. One of juror number 1's questions was if her parents were negligent. Juror number 1 also asked her a series of neutral questions about the time Maya Kowalski was in the EEG room. Observations or notes she may have made upon Maya's return, and similar clarifying questions. asking if Maya Kowalski's parents were negligent just 1 week before the disqualification motion undercuts J. Hatch's claim that juror number 1 was biased against J. Hatch. Further, these other questions by juror number 1 continue to demonstrate his efforts to clarify disputed evidence and in no way shows any final or fixed opinion. On October 24th, juror number 1, in addition to asking similar questions to Dr. Crane, like those to Dr. Kirkpatrick about the scope of knowledge of CRPS in 2016, juror number 1 also asked Dr. Crane about the use of and FDA approval of high-dose ketamine in the United States and other parts of the world. While the court did not allow the questioning concerning third world countries, the tenor of these questions is consistent with J. Hatch's theory that the medically induced coma was dangerous to Maya Kowalski. Previously, on October 4th, juror number 1 asked Dr. Cantu, who performed the medical induced coma in Mexico, about it being a highly controversial and unacceptable procedure. Multiple spelling corrections and removal of all the capitals. This is yet another example of juror number 1 seeking to understand complex material being presented to him and is in no way indicative of showing bias against J. Hatch or coming to a final or fixed opinion in the case. In addition to these questions, there are numerous questions by juror number 1 that sought factual, clarifying information. While the court does not detail them all, the court sprinkles a few juror number 1 authored questions near the end of the trial to show juror number 1's consistent behavior of seeking clarity in and challenging disputed evidence. On November 1st, juror 1 asked whether Nurse Flores took Maya Kowalski to the chapel and whether Maya Kowalski remained on the same floor except the EEG room incident. On November 1st, juror number 1 asked Nurse Bali if she were still employed at the J. Hatch or the nursing industry, and whether Maya Kowalski ever mentioned staff that she was not too keen on. This was the breath of fresh air comment. On November 1st, juror number 1 asked Kathy Beatty if she used an official hospital camera to take the January 6 photos and confirmed that she did not use her personal phone camera. On October 30th, juror 1 asked Dr. Levy, concerning ketamine levels in the United States and other places in the world for normal anesthesia versus CRPS. On October 27th, juror number 1 asked Dr. McCain to clarify the testimony concerning the psychological contribution and its relationship to physical components. On October 24th, juror number 1 asked Dr. Crane about the application of the Budapest criteria and whether CRPS symptoms can reappear during life. Juror number 1 also asked Dr. Crane concerning the efficacy of certain of the Budapest criteria, specifically body part temperature differential and body part discoloration. On October 19th, juror 1 asked Dr. Michelle Smith about her testimony of psychotropic medication with respect to ketamine. Juror number 1 has noted this was the first time the words ketamine and psychotropic drug have been used in the same sentence. He then proceeded to follow up on that with multiple questions about ketamine, brain fog, and hallucinations, which is consistent with J. Hatch's theme. On October 19th, juror number 1 asked Dr. Tepes Sanchez about the transfer from the ER to the PICU. Interestingly, juror number 1 wrote and crossed out, to a patient entering the ER can appear confusing, when in fact it can be a highly orchestrated flow of events by many staff members to assist in the best care for the patient. These questions and this crossed out statement is consistent with J. Hatch's theory of the case. By listing these questions, the court does not mean to imply these were the only questions juror number 1 asked, or that juror number 1 did not ask challenging questions to both sides. Far from it. Juror number 1, along with a couple other jurors, asked many questions, while some jurors only asked a few, and others were somewhere in between. And some of those questions most certainly were uncomfortable to J. Hatch, but as the court observed during its ruling on the juror disqualification motion, why would juror number 1 ask so many questions if he already made up his mind? During the court's ruling denying the motion for juror disqualification, the court had the benefit of having seen all of juror number 1's questions and observing juror number 1 throughout the trial. For instance, the court knows, through its observations of juror number 1, that he took about a dozen legal pads full of notes. The jury went through so many legal pads, the court had to order more pads during the trial. He constantly referred to his notes when formulating questions, and the court routinely had to wait for juror number 1 to complete the process of writing out his questions after the attorneys finished their questions. The tonnage of information presented to this jury was immense, and the court is confident the trial transcript will show whether the transcript is finished being transcribed. whenever the transcript is finished being transcribed. The court was advised it was ordered the day after the jury verdict and is still being prepared. These transcripts take a long time. The court could well see in real time juror number one's efforts to make sense of difficult, complex, and very conflicting information being received by all the jurors. That information gathering process at times may have seemed acrimonious to the parties, including J. Hatch, but it is consistent with the process the court sees many in law enforcement use routinely to test information given to them. You want to know something funny? I was today years old when I first used the word acrimonious. I've never read that word before. I've heard it, but I've never said it. Like in my life. And I have a weird memory for things like that. Under our system of justice, we empower our juries to decide difficult cases. The jury's job is to determine what the facts are. Florida Standard Jury Instruction 601.1, they are permitted to use reason and common sense and draw reasonable inferences from the evidence. Jurors are instructed they are to evaluate the believability of all witnesses. Can you get me some water? Did Mom get water? Did Mom get bottled water? Oh, good. Ooh, that looks really tasty. Is it you made hamburger stroganoff? Caden. Yum, yum. Okay, so here we go. Let me speak briefly about witnesses. In evaluating the believability of any witness and the weight you will give the testimony of any witness, you may properly consider the demeanor of the witness while testifying, the frankness or lack of frankness of the witness, the intelligence of the witness, any interest the witness may have in the outcome of the case, the means and the opportunity of the witness had to know the facts about which the witness testified, the ability of the witness to remember the matters about which the witness testified, and the reasonableness of the testimony of the witness, considered in the light of all the evidence in the case and in the light of your own experience and common sense. That's the instruction to the jury. That is precisely. Oh, thank you. We have Deer Park water. Oh, it's not Deer Park. I have to spit it out then. Ooh, yuck. Deer Park, please sponsor the show. This Pure Life stuff is not going to cut it. All right. This is precisely what juror number one did in this case. Juror number one's questions do not show bias. Instead, they show juror number one's efforts to make sense of the material presented to him. Florida allows civil jurors to ask questions governed by the same rules as evidence as the attorneys. In utilizing that option, juror number one was fulfilling his role as a sworn member of the jury. Few jurors have attended law school and should not be criticized if they preface their questions in the manner at odds from how an attorney would do it. This is why our process allows the attorneys, outside the presence of the jury, to object to a potential juror question. Regardless of the niceties of the proper form, it would be the height of arrogance to think that a juror, and juror number one in particular, is somehow operating improperly because the questions asked do not fit neatly into either side's version of the case. It challenges what the witness says, presents conflicting evidence, or asks questions that raise issues not presented by the attorneys. That does not show bias. It shows a search for the truth. The judge has done so much work on this. This is amazing. J. Hatch, in its reconsideration motion, repeatedly asserted that juror number one was biased as evidenced by his questions. The court rejected that theme in denying the juror disqualification motion and continues with that finding. The court could not more fundamentally disagree with J. Hatch on this point. We cannot get farther apart, says the judge on this opinion, especially after watching juror number one throughout the trial. J. Hatch's repetition in saying that juror number one was biased based on the content of his questions simply does not make it so. No matter how many times you say this, it's not going to happen, says the judge. It's not true. You can yell it, you can shout it, you can say it. It's not going to be true. And stating something forcefully, even repeatedly, does not make that statement correct. A quick analogy demonstrates that point. The undersigned, that's the judge, could say he has a full head of hair. Whether said one time or 100 times, the reality is, the undersigned, as the undersigned's young son reminds, the undersigned has a small island of hair amidst a sea of baldness. Saying the undersigned has a full head of hair does not mean the undersigned, in fact, has a full head of hair. I don't. I'm going to read that again. I'm going to put the judge in there. Judge Carroll could say he has a full head of hair. Whether he said one time or 100 times, the reality is, and Judge Carroll's young son reminds, Judge Carroll has a small island of hair amidst the sea of baldness. Saying the judge has a full head of hair does not make the judge, in fact, have a full head of hair. He does not. I believe Megan calls it the tuft of justice, the little bit of hair. We've seen it. We love it. We typically don't comment on people's personal appearance. The judge has included that in here. So clearly he says fair game, and he uses it quite effectively to prove a point. I love that. And juror number one's questions do not show bias against J. Hatch and do not show a final or fixed opinion prior to jury deliberations. J. Hatch began this section of its argument with the implication that juror number one will lie during the juror interview and points to the strength of its evidence of alleged misconduct to prove that assertion. The court understands that the standard to obtain and prevail at a juror interview is high and difficult for J. Hatch. That is by design, given the strong public policy against harassing jurors or attempting to ascertain an improper motive to upset a jury verdict. Just because it is difficult, though, does not permit a party to wholly distance themselves from the facts of the case. Can we back up just for a moment? Can you indulge me? A quick analogy demonstrates that point. The undersigned could say that he has a full head of hair. Whether said one time or 100 times, the reality is, and the undersigned's young son reminds, the undersigned has a small island of hair amidst a sea of baldness. Saying the undersigned has a full head of hair does not mean the undersigned, in fact, has a full head of hair. I don't. Thank you, Judge Carroll, for that. This should go down in the halls of history of just amazing literature composed by judges in epic rulings that reverberate through the halls of justice. Hair or no hair, Judge, this you can stand tall and be proud because even in your baldness or near baldness, who's ruining my sound effects? Hang on. You've led the people to truth. I bet the Recovery Addict can totally adopt this entire paragraph as his own words. All right, thank you, Judge Carroll. We'll continue on without the music. All right.
When are we going to break for lunch, Judge?
Just because it is difficult, though, does not permit a party to wholly distance themselves from the facts of the case. Wholly distance themselves. These words, the judge is not using these words lightly, right? He is not using these lightly. The court's view on the proper scope of a juror interview is not impacted by J. Hatch's claimed strength of its evidence. There is no need for the court to reconsider the scope of the juror interview. Post-discharge juror note, Part C. Finally, J. Hatch complains about a post-verdict note J. Hatch contends was authored by juror number one's wife and distributed post-verdict and after the jurors had been excused as to the jury in this case. In context, that note was apparently delivered later in time to a collection of already discharged jurors who deliberated and alternates who attended a dinner together. Dinner, yummy, it's good. I'm glad they got to meet together and got some food. This post-verdict and post-discharge note contained a statement of appreciation attributed to plaintiff's attorney Nick Whitney, together with various YouTube links to various YouTubers who commented on or broadcasted the trial. Hey, Judge, thanks for watching. J. Hatch suggests this is evidence of the plaintiffs improperly contacting the jurors. There is nothing wrong about former jurors connecting with each other after discharge to discuss their shared experience. The court knows in scores of jury cases, some jurors, after they have been discharged as the jury, meet each other socially for drinks or dinner or other activities. Given the length of this trial, the court would have been surprised if none of the jurors or alternates met socially after being discharged. Dinner is yummy, says Kurt. I concur. I concur. Even assuming juror number one's wife distributed this note at a dinner, after the discharge of the jury. Nothing about the content of this note suggests any juror or alternate violated any of the court's instructions or otherwise engaged in juror misconduct before or during the trial. As such, this post-discharge juror note is not indicative of any alleged juror misconduct, and it certainly is not evidence of plaintiffs asking to the internet to investigate juror number 1. He says, when I talk about you deputizing the internet, and I make that statement saying you guys should not do this, I was looking at defense. That's what the judge is saying here. This was not the plaintiff. This was defense that I was talking about. I was talking to you. Now, let me point something out here. Notably, in this comment, he makes reference to this statement of appreciation attributed to Nick Whitney, but he doesn't make any ruling on that. All he says is it has nothing about misconduct. He may ask Nick Whitney about that statement. That may come up. Conclusion. J. Hatch has not shown the scope of the court's interview to interview juror. The court's juror interview of juror number 1 is improper or insufficient. There is no basis to reconsider the court's prior order setting forth the only subjects for the juror interview. The court denies J. Hatch's motion for reconsideration. The interview will occur tomorrow under the conditions previously outlined by the court. Done and ordered in Sarasota County, Florida, January 2nd, 2024. And then it was served on everyone. Done. Page 14, done. That is the judge in his greatness, responding in a way only the judge can. Did the jury vote on where to go to dinner? Were they unanimous? Ooh, good questions. Good questions. There is a lot in here that I think what is most impactful for me is there are some key moments where the judge, in speaking, and I would say he's speaking directly to the defense here. I haven't seen any of here where the judge, he signed it at 4:10 p.m. today. I can't see anywhere it goes towards the plaintiffs, but he has some key words here that they bear more weight than the letters on the page give them credit for, because of the legal implication of them, and maybe some of the LawTube greats who we know and love will be able to comment more on this. But specifically when he talks about the complete lack of the materialness of these facts, the fact that they're saying something over and over does not make it true. It seems that the judge has a very narrow opinion of the methods that the defense is using to get to this point. Although he has granted the juror interview, probably for appellate, to protect against appeal only. He's basically saying it's not the weight of the evidence that's causing this. It's just that I want to make sure there's no appearance of a problem. Does not demonstrate good cause. Let's see. I wanted to pull one thing out here, just briefly. Entitled to no relief on this claim. That's shutting it down. No relief. There's nothing. You deserve nothing. Good day, sir, on that claim. This part, shockingly, that the judge says, the judge, I am shocked that you would make this allegation, that you would say, Judge, we asked for a juror interview. We said we just need a juror interview just to find out if this happened or not. And now you're coming to us and saying, Judge, you know what? The interview hasn't happened yet, but you know what? He's going to lie to you. He's going to lie. He's going to look at you. He's going to raise his hand and say, yes, on my honor, I so swear. And then you're going to ask him the questions, and he's going to lie through his teeth. And you need to ask more and more questions until you can catch him in that lie. The judge is shocked at that, saying that we do not believe that he will tell the truth when sworn to tell the truth. Those are incredible statements. I think the judge is using the term incredible. Let me read you the definition of incredible, because we throw that word around. Hey, that's incredible. Okay, define incredible. Let me read it out of the dictionary here. Impossible to believe. Impossible to believe. We use it like, wow, that's crazy. That's pretty cool. No, it is impossible to believe is the number one definition. We use it more in the difficult to believe or extraordinary, but I think the judge uses it in the first sense of that term, that it is impossible to believe. There is scant, if any, evidence underlying these ambitious statements. Let's see, we've got another one here. Lots of juror number one questions. I love how much homework you did on this one, putting these parts together. And not just to prove the one side, but to prove all the way throughout where he brought in the times that juror number one supported, asked questions that would have been in favor of Jay Hetch's argument, like, hey, we're starting to resonate with this guy. You know, I think he's on our side. As they're pouring over these questions and trying to ascertain what's in their mind, this is what they would have thought, because he was asking questions like, hey, yeah, that does seem a little weird. You know, explain this, witness. Don't you know, the more times you say something makes it true. I think I can. No, it doesn't work with hair, apparently. The only thing that would have made this better is if Judge had read this out loud instead of just typing it. There are parts of this I think we are going to hear tomorrow in the hearing, or we're going to hear some of these same themes in the hearing tomorrow. But it's going to be in probably... I don't know. I don't know if the defense is going to stand up and object and say we'd like to just put on the record, or the judge might have some statement to this. I'm not sure if it'll just let it go or not. It's done and ordered. Everyone the defense put on the stand was uncredible. They assume because they manipulated truth, heck, everyone else is doing it. Judge Carroll had respect for the former judge on defense, but he's had enough of the bull. I will tell you, Judge Carroll has a ton of respect for Attorney Altenbrand. He is somebody he's worked with professionally for a lot of years, and that's where all the cool words are. Give us some examples, Kurt. Help us out. He has a ton of respect for him, and a lot of times when he was asking Mr. Altenbrand questions, it was basically getting a free insight into what an appellate court might think about this case when it moves forward. And we saw that in the responses. Oftentimes the judge would say, just appellate reasons, just let you know this is something the appellate court would look at. He's saying I've been there, I've done that, this would raise a flag. And so the judge sort of had like a free pre-appellate review with that. And we saw some of the questions and a little deference to that way throughout the trial. But towards the end, he's like, look, I realize I know who you were, and I know who I am now, and I know what position you hold, and I'm going to stand by my position. This is my job to call those balls and strikes, and I'm calling them. And then we're going to send it up, and the appeals court will have to decide. But at this point, I'm calling. Amber, sorry, I missed your call. I was going to answer. I thought it had just come in and it hung up before I clicked the button. Give me a call again. Cleave, dust, fast, sanction. You know, I failed English the first time through, Kurt. And now you're giving me like I could handle this spelling test, but this is advanced test. Amber's on the phone with us. Amber, you had a question. What's on your mind?
I did. Well, the first one is, how about all of those receipts?
Oh my goodness! The judge had every single one.
I have been crying tears and coughing fits. It's so terrible, but this was absolutely hilarious. I just want you to do one thing. Can you do one thing for me?
The sworn statement for Shapiro is what you wanted, right?
Yes. I want you to look at the paragraph for Shapiro at the bottom of page 2, because that's where I stopped reading pre-live stream. I'm trying so hard not to laugh because I don't want to cough on stream.
Yeah, don't do
that.
But
we got to look at the Shapiro stuff and the sworn statement.
Okay, hold tight. Okay, I've got to pull it down from the court really quickly again. Just 1 second. accessing the court right now.
Did I not send it to you? I can send it to you.
You did, but I need it on a different device. It's the notice of filing trial, 12 pages, right?
Yes.
Okay. Let me bring that up over here. Actually, I need to make this one smaller. Shrink this guy down, and we'll bring this one over the top.
Okay, last question before you start doing this comparison.
Okay.
Am I right that the little RAs are tell you that you don't have as much hair as you think you do?
They just say that from certain angles in back, some skin is more visible, right? They that like from back here, there's a little more what do you call it? Luminosity visible. There's a little more reflectivity going on through the hair. It's not that it's a bald patch so much that it's thinning. And apparently,
I thought you were reading that. I thought you were reading that paragraph with a lot of emotion. That was personal.
Well, I read it knowing that at some point I would have to reread or re-listen to this and say how true this is, and look what we have become. So, Matt Bond says, on the record, let the record show, what are JH sniffing the brainy bits aren't braining. Thank you, I'm
going to go before I start
Amber,
coughing.
thank you. We'll catch you later. Bye. So Amber says, go look at this motion that was filed today, and this is the affidavit of Mr. Shapiro. You have to realize the judge just called out Mr. Shapiro specifically. So he says, my name is Ethan Shapiro. Comes out Ethan Shapiro, Esquire, and deposes and says, my name is Ethan Shapiro, and I'm over the age of 18 and have personal knowledge of the matters set forth herein. I am a member of the Florida Bar in good standing since 2003. Good. Since 2003. Has he been a member since 2003, or is he in good standing since 2003? I'm not sure from the wording. I'm not sure which it is. Probably member. I represent Johns Hopkins All Children's Hospital in the above styled cause and have served in that capacity as trial counsel since the outset of the case. Meaning I've got this all over me. I've been walking in this since the beginning. At no point have I asked, directly or indirectly, that any person initiate communication or attempt to initiate communication with any juror or alternate juror in the reference matter, nor have I attempted to initiate any such communication myself in any form. I haven't reached out to the jurors. Regarding that letter that was purportedly sent to the jurors that was incorporated into the defendant's motion for reconsideration of scope of juror interview, a screenshot of the letter was voluntarily sent to me by an alternate juror. I have not asked, directly or indirectly, that any person take any action that I could not take myself, including any action that would violate Florida rule of professional conduct. Wait. And you've signed this, Mr. Shapiro. You signed this with your name. And it's notarized. Who is that? Tracy Lesser, or something similar to that. Notary Public, Tracy Lessing. It says that you yourself, you signed this document. You said, I have not asked, directly or indirectly, that any person take any action that I could not take myself, including any action that would violate Florida rule of professional conduct. Let's do a quick check, shall we? Let's jump over here to our good friend Google, and we're going to do some higher math. We're going to say Florida rule of professional conduct 4-3.5 D4. And do a quick search. Okay, here it is. Let's see. Impartiality and decorum of the tribunal. That's 4.3.5. And then we need to get to part D4. So let's get to D. Communication with jurors. A lawyer shall not, after dismissal of the jury in a case which the lawyer is connected, initiate communication with or cause another to initiate communication with any juror regarding the trial, except to determine whether the verdict may be subject to legal challenge, provided a lawyer may not interview jurors for this purpose unless the lawyer has reason to believe that grounds for such challenge may exist, and provided further, before conducting any such interview, the lawyer must file in this cause a notice of intention to interview setting forth the name of the jurors to be interviewed. A copy of the notice must be delivered to the trial judge of opposing counsel as a reasonable time before such interview. The provisions of this rule do not prohibit a lawyer from communicating with members or the veneer of jurors in the course of official proceedings or as authorized by court written order to the court. So he's saying that you are not allowed to initiate communication with any juror and may not interview jurors for this purpose. Let's see. Lawyer shall not cause another to communicate with anyone the lawyer knows to be a member of the veneer during the trial of the case which lawyers connected communicate or cause another to communicate with a member of the jury. Wow, that might be close on part 2, not 4. But part 2, during the trial of a case with which the lawyers connected communicate or cause another to communicate with any member of the jury. During the trial of the case that's during the trial. And that was during the trial. During the trial of the case. No, that was after. What was the date of Mr. Shapiro's it has to be during the case. After the dismissal of the jury in the case which the lawyers connected, initiate communication with or cause another to initiate communication with any juror regarding the trial, except to determine whether the verdict may be subject to legal challenge. So with him telling them to dig it and find everything they can and then posting the numbers and publicly getting that information out there, is that what the judge is saying he may have done? Interesting, I say. Interesting. Juror stalking is not initiating communication. But look at this part here, because I think this is probably more applicable. Let's go back to. Oh, this is the wrong one. Did I close the wrong document? Give me a second. We'll pull up the right document again. The judge cites another case. We'll bring this one over. Let's see. The judge cites right at the very beginning, and we'll look at this one really a little bit closer, because I think that's the one that he cited it twice. So I think it means a lot to the judge, and he thinks they might have a problem here in this area. And that is, let's see, right here. Baptist Hospital of Miami versus Maller. We need this reference. Let's do some Googling on this, okay? Let's see some summaries here. Summaries, this is the holding. The trial court abused its discretion in authorizing an inquiry of jurors based on the matters that adhered in the verdict. Holding that the trial court abused its discretion authorizing an inquiry of jurors based on matters that adhered. Finding no actionable juror misconduct where jurors in personal injury action allegedly told defense lawyer post-trial that defendant Hospital had won the case, but the jury had awarded brain damaged child $1.5 million out of sympathy. The judge says that there's a strong public policy against allowing litigants to either harass jurors or to upset a verdict by attempting to ascertain some improper motive underlying it. So this is what he's talking about. The attempting to ascertain some underlying improper motive. So this is case law in Florida, right? This is case law, or at least there's strong public policy against this. So possibly is that against the rule, and is that what Mr. Shapiro did? Or is that what the judge is saying Mr. Shapiro did? Let's see. Recovery Addict, Peter Tragos went over the filings by the Florida attorney who is putting on record she did not rep jury number 1, wife or family member, plus she addressed more. We did cover that. Salisbury. That was a great filing. We did cover that as well. She basically said, and she was also quite eloquent in her denial, and almost you could tell that she was offended by the allegation that she was being associated with something that was improper. It was something else to read. It was really good. Actions that I would not take myself or could not. He says that I would not take myself or could not take myself. Let me go back to Mr. Shapiro's filing here. He says could not take myself, not would. Her offense was well founded. She was quite upset. She was in court. She was there when I was there. She was there in the courtroom. She was ready to, to stand up and let herself be heard if need be. But the case law recites the public policy reason for the ruling, which is the case law. This filing is really cathartic after all these defense motions these past couple of weeks. AKA the cat lady. I think what this shows is that the judge is trying to make sure, as he has done throughout the entire trial, he's tried to make sure that this was appeal proof in every way that he could, realizing that it is groundbreaking. It's a case that is, approaching an area where many cases have never gone before. It's new territory in this level of judgment of award for this type of thing, especially when you're talking about liability. Specifically for these facts, and they're difficult facts, and even words to talk about on YouTube that YouTube doesn't like us to use at all. But in the fact that Maya's mother took her own life, and assigning a financial judgment against the hospital for their portion of responsibility for that whole area, I believe is new ground in the Florida court system. Ivan, good to have you here. Some people were asking about you today. Glad to see you're okay. Can Salisbury make a bar complaint? I don't think she would. I don't think she would make a bar complaint. I think the step she took in her letter, in her sworn affidavit, was basically saying we would ask the court to take notice of this and show that I have done everything appropriate. They can't damage my image and character by just throwing my name out there and saying that this was a problem when it wasn't. And she says, and they're saying I did things that I did not do. I did not represent the wife. I'm in Clear Lake, so we live so close. We do need, here's what I need. I need somebody who's going to be in court tomorrow to text me. We've got a couple people. It would be helpful if you've got a little bit of tech experience. That's it. But if we could do it offline, that would be fantastic. Kirk's going to give a legal explanation tonight as well. That's going to be wonderful. There's going to be, I think there's a couple people that are going to be on tonight talking about this. Obviously, there's a lot going on in this area as we lead up to the hearing tomorrow, which is only supposed to be an hour long, starting at 3 p.m. in the afternoon. It's not a big one by any means. Let's see. I think we can, Kurt, I think I got you covered here. We're good. We're good, man. Got you on the redirect. Tomorrow, the case tomorrow is going to be at 3 p.m. We're going to go live at 9 a.m. With our regular morning show. We'll do the regular hump day theatrics and shouts and everything else. We'll sing some happy birthday songs to all those who are celebrating their birthday. Trying to get back in getting caught up on the birthday wishes. I do apologize to those who had to just take a generic birthday song this morning instead of have everyone's names. But let's see. So we're going to start early in the morning. We'll probably do a little court hopping. There may be a couple documents that drop late tonight, so we'll keep an eye on the docket and see if anything else pops up. Just because there's a chance that something comes in from the plaintiff's side in response to some of these documents. Obviously, this one they don't need to respond to the judge's ruling, but there has been some other stuff that came in that there might be some filings that come in at the last minute. So we'll watch for that. They might cover that. We might do some court hopping just because there aren't big trials right now. The courts are just sort of getting back in the swing of things after the holiday. Very few courts wanted to have juries sit over the holidays. So we're just waiting for those court schedules to pick back up, and we'll be joining a new case very soon. Is there? Let's see. Hope Lawyer covers this. He's been great covering this. I realize he's got some. This is in his backyard, and this is a challenge. It's not as challenging for me because I am not a lawyer, and because I'm not a lawyer, I don't have some of the same professional restrictions on commentary that we do love Attorney Melanie Little here, and Brandy's here. Brandy, how are you doing? Happy New Year to you, Brandy. And happy birthday. I missed your birthday. We should probably sing to you, Brandy, because it was your birthday just a little bit ago. But I don't have some of those same restrictions professionally. Obviously, Peter Tragos is a practicing attorney. He's down there that's in his backyard. So this is not just something he reads about on the news. These are faces. These are people he may see in court as he's representing clients, or he may be opposed to or on the other side of in some court cases. And it changes things quite a bit. And it makes him have to be very cautious about what he goes into and what he covers for that reason. But from what he is able to share, he does a fantastic job. He's flying home tonight. Was it a members only stream for his tubing? And I don't want to out him, but where did he go on vacation? Can anyone tell me? Where did Peter Tragos go on vacation? Just general area. I'm not looking for an address or something. I'm not trying to out him if you know that. But North Carolina, boom. Was he? Because he was up in an area the same time I was up in an area, and I was up in the mountains up around Asheville, and I think he may have also been up in the same area. Was he in Asheville? Okay, because he says he got snow and we got snow at the same time. So I think we probably I don't know. Maybe I passed him as I was in the fast lane. I'd like to think that I passed him. We also went out and did some tubing and stuff. We were both in Nashville, so that's cool. I'm guessing his cabin was a little bit bigger than ours. I think they threw a pretty good sized party. All right, he was tubing too. All right. With that said, tomorrow that's where we're going to be. We're going to cover a little bit. If anything comes up tonight, we're going to keep our eyes out for that. I'm not going to do another live. If there is another thing tonight, I'm not going to cover it tonight. We would cover it tomorrow. You guys need sleep just like I do, and so we're gonna watch what happens on the filings. We're working with we are on the media pool, so we're working to get the media access to the video and everything. We're putting that together. If you're going to be in court tomorrow, please. Give me a quick buzz so we can get that sorted out. I need some help there. Otherwise, I have to hire somebody really quickly. But that said, what sleep, says Tisha. Yeah, it's overrated. Whatever it is, Tisha, it's overrated completely. Let's see. Thanks for the kind words. We are going to go over to Kurt. Kurt is starting in like 15 seconds, and so we're gonna let him cover this. Kurt obviously is going to cover this from the legal perspective. I think it will probably interest Kurt, and he's probably caught a couple of these words and the phrases that the judge used. That's quite telling. Quite telling. Kurt's just chilling. He's just chilling. It's good. Now we're going to go to bed for the night. We're not going to start again tonight. So this is our last one, Kurt, I promise. Once again, big shout out to some of the other great people who are out here in the world of true crime, in LawTube or LawTube adjacent. Kurt, Melanie, Megan, Rob, Peter, many, many more. Good friends all over the place and just great people. Ian Runkle. If you don't follow Ian Runkle, you should. Just great people, and what I can say is that as I meet more and more of these people and get to know them a little bit better, they are phenomenal individuals. And these are not just a lawyer who wants a YouTube channel. We've got really some awesome people out there with very different perspectives, and who are able to give you good analysis and just a breakdown of things. I think LawTube doesn't realize what a good thing we have with all these amazing lawyers who are willing to provide free analysis of everything that we're so interested in. So big shout out to all of them. Please follow all of them and watch and listen and support them. That would be great. I appreciate them as I appreciate all of you. Tonight when you go home, please hug the people you love. Smile at someone, make their day just a little bit better, and please stay safe till we go live again. It'll be tomorrow morning at 9 a.m. Until then, we're going to run over to Kurt at Uncivil Law for his breakdown on this reading from the judge, because the judge has issued an order, and guess what? He's not expanding that interview with juror number 1. Nope, it's going to be limited. It's going to be short. It may even be less than an hour. We'll see what happens. We're going to be watching that tomorrow. Please join me for that one. That's going to be at 3 p.m., but we'll also be doing some fun stuff before then, so don't miss it's like the tailgate before the party, right? You guys have a great day. We're going to check out here. Have a good night. We'll see you guys later. Bye-bye.